West Bengal, and for a completely different reason in Jammu and Kashmir. So land reforms failed, and there is no greater contributor to the failure of land reforms than the judiciary. The word compensation was interpreted by the judiciary to say compensation shall mean market compensation. Then the parliament amended it and introduced the word amount. The judiciary said amount cannot be arbitrarily decided. Then when you had no other alternative, all land reform legislations were placed in the 9th schedule. And parliament said you can't attack the 9th schedule in the Supreme Court. And finally 19(1)(f) itself had to be removed. So property ceased to be a fundamental right as a result of this long struggle. And that is, a battle of many decades. So when you are thinking of the judiciary and its potential, don't forget that the judiciary largely comes from the landed sections of society. And their inclination is also to make sure that you don't have progressive land reform legislation, etc. It is against that background that we must look at the public interest litigation. And finally, when I go through some more aspects related to public interest litigation, I'll try and point out how I think it's worth analyzing PIL itself differently. All of you are aware that the first major constitutional crisis in India came when Indira Gandhi declared the emergency. And during the emergency, the Supreme Court was approached by many people. Habeas corpus petitions were filed in several high courts and in the Supreme Court. And the Preventive Detention Law, the Maintenance of Internal Security Act, that was a law that was used, the midnight knock on the doors of those who did not agree with Indira Gandhi. That was, known to everybody. Unfortunately, during that period, the Supreme Court failed to protect the civil liberties of people. So a Supreme Court which was, in favor of the fundamental right to property, failed to even defend the fundamental right to civil liberty. And as a result of this process, the judiciary was in a very bad state. Fortunately for us, elections were declared and Indira Gandhi was defeated. And there was a huge uprising of people, and through the secret ballot, she was defeated and an opposition government came to power. And there was merciless criticism of the Indian judiciary. And the judiciary had no answers, all the Supreme Court judges had no answers to give. As a result of it, the judiciary, wanted to emerge from this post-emergency awkwardness. It was a catharsis for the judiciary. And it is in that background that the judiciary of India becomes a progressive judiciary. So PIL actually originates in that background when the judiciary and the judges are taken to task by people in this country, and against that background something new begins. But fortunately for us, that's also a period of time when in the Supreme Court you had extraordinary judges. I'm sure everybody in South Asia would have heard the name of Justice Krishnaiyer. Krishnaiyer was certainly an extraordinary judge. It's a miracle that somebody like him found a place in the Supreme Court. And then of course there was P.N. Bhagwati, there was Chinnappa Reddy, there was D.A. Desai. So there was a group of judges whose understanding of social issues was way above the average understanding of the Supreme Court. It is in that context that public interest litigation picks up momentum. And if you look at public interest litigation, I think it created two kinds of innovations. One kind of innovation was in respect of procedural matters, and the other kind of innovation was in respect of substantive matters. So let's look, is the procedural, which in a sense is more important. I think it's on the procedural that the PIL is strong. On the substantive, I am of the view that it is not as strong as one imagines, and perhaps I'll try and come to that at a later stage. Insofar as procedural aspect is concerned, this is the first time that we made a departure from common law. You are aware that in our constitutions, and I think that's true of all constitutions in the region, we have the 5 writs the writ of habeas corpus, the writ of mandamus, the writ of prohibition, the writ of certiorari, and the writ of quo warranto. These 5 writs are called as the prerogative writs. What do you mean by a prerogative writ? A prerogative writ is something which His Majesty or Her Majesty used to issue in England. And so we borrowed the prerogative writs, we borrowed the common law traditions, and the public interest litigation became a very important departure from common law tradition. And that departure was in respect of locus standi. Who can come to the court? The petitioner need not come to the court with his own cause. The petitioner can espouse the cause of others. And for people like me and Karamat, this is not new. Because in labor law, the essence of labor law is that a trade union espouses the cause of the workers. In fact, classically labor law used to say that the individual worker cannot go and seek relief in a labor court. Even though he may be dismissed, his case could be taken up only if the trade union or if a group of